That thing out there. Yeah. Like it was here. Why am I not? I cannot see this here.
Catherine, are you okay if I share my screen, make sure the PowerPoint works?
Let me see if I can.
Are you
There we are. Yes,
okay if I share my screen?
yes.
Okay.
Yeah, can you hear me? I'm having trouble. I'm on my phone right now.
Oh,
I
okay.
was having trouble getting in on my iPad, on my laptop rather, so I'm on the
Yeah.
phone. But yeah, that's fine.
Okay.
Trying to figure out how to mute this though.
Now oh boy.
Wait a minute. I don't want to see me though. No, that's what I do want to see. Where is?
I cannot see everyone.
Oh,
Can you see my PowerPoint?
Yeah.
right here.
I can.
Let me see if I. No, I can't. Backgrounds. Can you see my face?
Well, I can't see anybody but my PowerPoint right now. I'm gonna stop.
I see.
I'm gonna stop sharing for a minute.
Okay. Let's see if I can pull this up on my pad.
Oh. I don't know that I gotta see everybody. Usually you can see everybody on the side, but when I shared my PowerPoint, I couldn't see anybody. Mm-mm-mm. Let me share again. No, I don't see anyone. Oh. I don't know why it is.
Get to sleep. Let's see if I can.
I'm not going to do that. Carol has no audio. Ooh. That would be a problem.
Yeah.
And Fran has no audio.
Can you
Hmm.
hear me? Can you hear me? That's Catherine.
Yep, Catherine, I can hear you.
Okay. And I can hear you, but I don't know how to mute this on my phone. I can't see any.
Yeah, I think if you tap
weird.
like the bottom,
Place to the left. Yeah.
it might,
Yeah, I'm trying to.
yeah, I know on the phone it's sensitive, so.
Well, I'm trying to still work with my computer here, but I can't get it. I think there's something wrong with my laptop.
I
Let's-
can't see, like, I can't see participants. Usually they come up on the side of the PowerPoint, but nobody's showing how we're going to do this, but. Hmm. Zoom is great when it works.
Yeah, well, there's something going on here with my computer today.
Carol doesn't have video or audio. Wow. Oh, that's a little bit problematic. And can I change the view? I don't know what to change it to, Carol. Hear me.
There is a screen here now. When I clicked on a little arrow that showed the Title IX, that BPW, just the plain screen like on the phone.
So can you see my PowerPoint?
I think it is. It's got a big BPW emblem. It says Title IX regulations.
Yep, that's my PowerPoint.
Yes,
so we got that, but we don't. Okay, Fran has audio and sees the PowerPoint. All right. So we don't know what. Yeah, side by side gallery. That's what I need. Yeah.
21st.
I gotta figure that out. Let's see. Side by side. How do I get to that, Carol? Oops. Not doing that. Okay, Nancy has both. I don't know how to get the side by side gallery. Just did. What did I just do? Upper right hand is where the view button is. Of course it is. Oops. View button. Let me see a view. I'll share. Let me share summary. All right, Carol, why don't I see view? See, mute, start video. Apps. Info. I don't seem to have a view button to show the gallery, so. Or I might have to go without that, so you guys are just gonna have to like interrupt me or something.
Okay.
Do you want me to get started, or what would you like to do?
Yeah, I think that's
Yes, yeah,
How many people are logged on? What do we have, about 8?
on the screen that I have, I can't see that.
I think under participants, I see 8, and that includes me and.
Hmm.
I mean, of course, I pack too much into an hour, so
Uh-huh.
I can get started if you'd like, and people can just kind of roll in as they do.
Mm-hmm.
Um, it's kind of funny because when Carol contacted me to do this, it was before the regulations were issued. And I kind of said to her in an email, well, I'm not quite sure how much information I'll have. So it's better to do this later rather than sooner. Well,
Right.
They were issued on the 19th of April, and there's a ton of information. So, are you okay if I start?
Yeah, as far as I'm concerned, it's Kathy that.
Kathy, so I have no way to mute people, so
Yeah, I can't right now on the screen that I have. I can't mute on this phone somehow, so I'm just going to try to be quiet.
yes.
I
So
can't.
yeah, and so
My stuff isn't working right here.
and it is what it is, and if there's background noise, we'll just work through it. But I'm going to get started because I really do have a lot of information, and I'm probably going to leave everybody with more questions than answers.
Uh-huh.
So if you'll bear with me, just going to kind of roll through this, and we'll see where we end up. And if we end up at the end with a lot of questions, maybe we have to have another, kind of gathering.
Meeting.
Just kind of,
Yeah.
yeah,
that's
yeah.
fine.
So yeah. So well, thanks for having me. I really appreciate it. And just a little bit about my background. I spent my career in public education, and I started out as a health and phys. There's the gallery. The gallery showed up. So, um, yeah, I started out as a health and phys ed teacher. I coached multiple sports, and then I kind of matriculated into administration. Spent some time as an assistant principal, everything at the high school level, and but I spent most of my career as a high school athletic director, and really my love for sports really is strong. Through my career, I really got involved and really had a passion for Title IX. I'm a child of Title IX, as I'm sure many of you are, having gone through gone through high school in the 70s and kind of watching the law kind of come in and take hold, and kind of things started changing. So I'm very fortunate to, have that passion and kind of follow the law for the last 4 decades. And so having said that, it has afforded me a lot of opportunities. And one of those is that I sit on the advisory board for an organization called ATICSA, the Association of Title IX Administrators. And they're a national organization, and they actually train the OCR, the Office for Civil Rights, the enforcement arm of Title IX. And also throughout my career, I'm very involved at the state and national level with the athletic directors associations. I'm on High School Today's publications committee for the National Federation of State High School Associations. And I started a consulting business, oh my gosh, maybe 20 years ago, when I was a working athletic director. And now in my retirement, I go around really a lot in Pennsylvania, but around the country, helping K-12 schools understand Title IX, mostly from the athletics perspective, is really the area I work in. And I'm also on the Upper Perkiomen School District School Board. So I just won re-election and rolling into my second term, which has been proven to be both challenging and very rewarding. So yeah, it's been a busy time, and but it's all good. And I really, again, appreciate this opportunity to be with you today. Before I dig in, folks, and get this thing rolling, just understand I'm talking about a federal law. So please don't take anything that I say tonight as gospel or legal advice. But I can assure you that my information is correct and factual. I have a working relationship with a lot of attorney groups, one being the attorneys at ATICSA and other areas. So please understand that. And please know that some of the comments that I make will reflect my opinion. But don't view that as legal standing. It's just kind of how I feel. And I'm certainly not here to present any political viewpoint. I'll just express my thoughts on a particular topic. So kind of to get things started, I think it's really important. And I think this is a problem with Title IX as people don't understand where it came from and how it got started. It's Title IX's pattern after Title VI of the Civil Rights Act of 1964, the portion of the landmark law that prohibits discrimination on the basis of race, color, and national origin in federally funded programs. And that's important to remember. The government granted preference that inspired women to push for affirmative action in Title IX was an executive order that was issued by President Lyndon Johnson back in 1965 to include sex as a criterion for minority group representation. And Title IX, somebody needs to mute, so we're getting some feedback.
Yeah.
Title IX was signed into law in 1972, so next month it's going to celebrate 52 years. And the regulations were codified in 1975 under the Department of Health, Education, and Welfare, which eventually was eliminated. And then the Department of Education, Office for Civil Rights, became the enforcement arm of Title IX, as well as many civil rights laws. It's not just Title IX. I think the history is important to understand where it came from. So Dr. Bernice Sandler, who is often referred to as the godmother of Title IX, was really the first person who realized that this executive order 11246 that Johnson signed could be used to help open doors of colleges and universities for women. And in 1969, Dr. Sandler, who held a PhD in economics, really faced considerable sex discrimination in her work in higher education. Her research base centered around why people weren't getting access, particularly women, to post-baccalaureate education. And so she fought really hard to gain that access. And she went to work, she was working on her doctoral or postgraduate program at the University of Maryland and was really told, you know, why should you even bother getting your doctorate? Because you're a woman and you're just going to, you know, go home and be a housewife. And she faced a lot of other discriminatory comments that were made towards her through her doctoral work. And because of that treatment, she decided that she would make it her life's work to make sure that nobody could ever say that to her again or treat her in that way again or anyone else. And she wanted to make sure that the law applied to everyone and that it didn't, didn't pass a woman's right. She didn't want to pass a woman's rights law. She wanted to pass a civil rights law so that all genders would be treated fairly. So Sandler went to work with a group called the Women's Equity Action League and a friend at the Department of Labor to win preferences for women in educational institutions. So it was Sandler and Wheel, Women's Equity Action League, filed complaints with 250 colleges and universities, including every medical school in the country, complaining they had too few women on their faculties. And they generated a lot of letter campaigns to the Department of Labor and members of Congress. They attracted an ally on the Hill early in 1970, Congresswoman Edith Green of Oregon, and a member of Wheel's advisory board. And they held the first hearings on what would eventually become Title IX. And over a 3-year stretch, the work of Sandler, along with these groups and politicians, resulted in legislation that was authored and sponsored by Representative Patsy Mink from Hawaii and introduced in Congress by Senator Birch Bayh of Indiana and Representative Green. And then on June 23rd, 1972, President Richard Nixon signed the legislation into law prohibiting sex discrimination in any educational program or activity receiving federal financial assistance. What you see on the screen now is the original 37-word statute. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. And we know today that this 37-word statute has now blossomed and mushroomed in a tremendously large body of law. It's always notable that, nowhere in this space does it mention the word athletics? And of course, athletics is my focus. And it's interesting to note that when the law was passed, it was initially aimed at higher education. It really pointed at access for higher education for women. That was the goal of the law, was to increase that access for women specifically to higher education. So Bernie Sandler, that's where she was kind of focusing on. But when you pass a civil rights law, you're not passing a woman's rights law, like Sandler said. You're passing an equity civil rights law, so that's why the law starts with no person. And when you pass the law that affects education, the way Congress can attach education is by saying, well, it's through the Commerce Clause of the Constitution. And basically, institutions who take money, educational institutions that takes money from the federal government, they are subject to the rules of the federal government. And that's why the last phrase, any education program or activity receiving federal financial assistance. So once they say that it's all education, it's not just higher ed or just K-12, it's all education. And that's how everybody gets kind of under this. And how athletics finds its way under it is a little bit more interesting, but it has to do with athletics as an avenue to gain access to higher education. There's like these three targets, if you will. There's admissions, financial aid, and athletics. And athletics does both admissions and financial aid through athletic scholarships at higher ed. So athletics is also a huge educational program at both the K-12 level, so middle school, high school, and then certainly lesser at the elementary level, but it's also, a big deal at the higher ed level. And so for those who played in middle school or high school and college sports, you learned a lot of valuable lessons. So it's important that we recognize that when it's discriminated, excluded, or denied access, which are the three sort of phrases inside of Title IX, that it would include sports as well. For all intents and purposes, interscholastic athletics, my world that I work in, K-12, are considered an education program. And in the interscholastics world, we talk about education-based athletics, an extension of the classroom, student athlete first, student first, athlete second kind of thing. And we're really one of 3 countries that has sports in our schools as educational programs. Canada and New Zealand are the other 2. And I always find that pretty interesting. So I think these are the general concepts you really need to understand about Title IX, that it doesn't just pertain to sports. It's not a sports law. The Office for Civil Rights considers athletics an education program. Title IX is the first comprehensive federal law that prohibits sex discrimination in education programs and activities that receive federal financial assistance. All public schools receive federal money. Many, if not all, private schools did or do in some avenue. Title I funds, Title II funds, free and reduced lunches. When we went through COVID, we got COVID money. That's all federal money. All schools got that. So, there's some kind of stream flowing into most schools. It doesn't only protect females, it protects all students, boys and girls, faculty and staff. Title IX covers sexual harassment and sexual assault in schools. And Title IX requires schools to maintain policies, practices, and programs that do not discriminate anyone based on sex.
I'm not on mute.
And it's really at the heart of the efforts to create gender equitable schools. Everybody is expected to receive fair and equitable treatment. And I just want to remind everybody and really note the impact of Title IX that it's had on girls and women in entering STEM fields of education, science, technology, engineering, and math, as well as career fields in law, medicine, and other disciplines traditionally pursued by men. And we really need to continue to support our young females in those areas. So just a couple of things from some court cases. These phrases kind of really stick in my mind as I talk to groups about Title IX. Congress enacted Title IX with 2 principal objectives in mind: to avoid the use of federal resources to support discriminatory practices in education programs, and to provide individual citizens effective protection against those practices. And Title IX was enacted in order to remedy discrimination that results from stereotype notions of women's interests and abilities. You know, the whole girls don't play sports, girls don't like sports thing, girls can't do math, girls can't do science, those stereotype notions. And that was really part of the effect of Title IX. And I love this phrase, interests and abilities rarely develop in a vacuum. They evolve as a function of opportunity and experience. I always hang on to that because isn't that the truth? It's what we experience. You know, our interests and our abilities will develop based on what we experience as young people. And that's why it's so important, especially at the K-12 level, to have a safe environment so kids can learn, so everybody can learn without any kind of harassment or intimidation. Every school must have a Title IX coordinator. That's been in the law for a while. And so that is really important. I think K-12 schools still struggle with this a little bit. They usually appoint somebody who's already wearing 6 different hats and then expect them to be a Title IX coordinator for the entire district, which covers, you know, all the nuts and bolts of everything Title IX. And usually the compliance in athletics will fall under the shoulders of the athletic director of the school district. And that athletic director should not be the Title IX coordinator. They can be a deputy coordinator to the Title IX coordinator. And they should be working with the Title IX coordinator to ensure athletics compliance with Title IX. So here we are, the 2024 Title IX regulations have finally been issued. And they were issued on April 19th, just a few weeks ago, and made immediate news. So just real quick, the timeline for what's called the NPRM, or New Proposed Rulemaking, which is the process that laws have to go through if they're going to be changed. It happened in 2020 under the Trump administration, and now it's happening again with Title IX under Biden. So in January and March of 2021, as soon as the inauguration, President Biden directed the Department of Education, he directed with 2 executive orders to review the 2020 regs, which came under Trump and DeVos, Betsy DeVos, the former Secretary of Education. And then in July of 2022, you got to follow the timeline on this stuff. The Title IX NPRM, New Proposed Rulemaking, was released. They were saying, here we go. We're going to start the process. They actually announced it on June 23rd of 2022 in celebration of Title IX's 50th anniversary. So the announcement's made, they're going to start the process, and I have there in bold that Title IX athletics, the regulations for Title IX athletics have not been changed since they were codified in 1975. So hang on to that thought. And then it goes through the review process. There's public feedback. There's national-wide public hearings. All kinds of things are mixed in and evaluated. There's public comment, and over 250,000 public comments received. And the Department of Education goes through every single one of those. So that's understandable why it takes a while. But we were waiting with bated breath for these regs to drop. We were told that the anticipated release time was going to be October or November of last year. Didn't happen. And finally, April 19th of this year, the first part has dropped. And we were told it's coming out in 2 parts. The first part came out on the 19th of April, and that addresses sexual harassment and the processes that schools have to use for sexual harassment complaints. And then the second part is coming out after the November elections, and that is going to deal with transgender participation in athletics. So, you know, you're hearing it. You're reading the news. You're hearing it. Here we go. And so, what I'm going to talk to you about tonight is some of that stuff. And you know, it is what it is. The new regs that came out on April 19th must go into effect by August 1st. And so right now, schools are really working with 2 regulations relative to sexual harassment complaints. They're still working with the 2020 regs. And at the same time, they're kind of bringing in the 2020 regs. So it's pretty crazy right now for K-12 schools. And sitting on the school board, I'm the chair of our policy committee, and we're going to be meeting this summer to change our policy 103 and 104. So here we go. These are the 4 areas I'm going to focus on. So fasten your seatbelt. Here we go. We'll start with sexual harassment. We got to understand the 3 forms of sexual harassment. So sexual harassment is unwelcome conduct of a sexual nature, or that is sex or gender based. There's 3 forms. There's the base. It's the based on power differentials. So it's that quid pro quo, something for something. You do this for me and I'll give this to you kind of thing. Sexual favors. The second form is the creation of a hostile environment, which is what we see most in K-12 schools, is that hostile environment sexual harassment. So it's unwelcome words or actions of a sexual nature, so severe or pervasive, it creates a hostile environment. And so that hostile environment is preventing someone from an education program or activity. And then the third form is retaliation, and retaliation is prohibited by law, both for anyone who files a complaint relative to sexual harassment, or anyone who files a complaint relative to athletics compliance. So retaliation is prohibited by law across the board. The sexual harassment regs that came out on the 19th of April address the changes that schools have to make on how to handle sexual harassment complaints as they're received and processed. And so there's a shift from the 2020 regs. The 2020 regs were very prescriptive. You got to do this, bang, 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 bang. The 2024 regs, kind of open it up a little bit more. And to the point at which, where in the 2020 regs, you could only process a title of sexual harassment complaint if it was a formal written complaint in writing. The 2024 regs, no, doesn't have to be in writing. It could be, hey, I saw this happen. I think you need to do something about it. And it could be an email. So it's going to be pretty interesting. And we suspect the sexual harassment complaints, especially at K-12, are going to uptick significantly. Sexual harassment in K-12 schools it's still a pervasive problem. And my guess, here's my opinion, my guess is that Department of Education, Office for Civil Rights are really saying to K-12 schools, get your act together. This is where the stuff happens. This is the culture we have to change at the K-12 level. So that's just my opinion and my gut feeling on it. But again, a school's responsibility is to stop, prevent, and remedy. One of the other big things with the 2024 regs is that all employees in the school district must be trained yearly. So it's not just the Title IX team of administrators, your Title IX coordinator, your investigators, your decision makers, your appeals people, your advisors. It's everybody in the district. So every teacher, every custodian, every employee, athletic coaches have to be trained. This is a huge shift. So busy slide, a lot of words, but this is kind of the bullet points of the significant stuff that's coming out of the 2024 regs. Full protection from sex-based harassment, prompt and effective action. Again, it's that stop, prevent, remedy, supportive measures for both the complainants and the respondents. The complainant is the person who, the terminology used to be victim and perpetrator. We don't use those terms anymore. The complainant and the respondent are the appropriate terms. Schools have to respond promptly and effectively and make sure that there's fairness, transparency. Everybody's got to be trained. You got to have unbiased decision makers. There's some flexibility for the schools to adapt regulations and grievance procedures. So that's kind of, a little bit flowing. Protect students, employees, everybody, including anybody, pregnancy or related conditions. And the next bullet point, I have it in italics. It's a big one. This one's the one that's causing controversy and challenges, is prohibiting discrimination against LGBTQ plus students, employees, and others. And that's where a lot of the heartburn is being generated. But again, protect people from harm when they are separated or treated differently based on sex at their school, protects everybody, and it supports
Not old enough to qualify.
right of parents and guardians to act on behalf of their children. and again, communication. So a lot of stuff, but again, here are the challenges that we're seeing, and I'm sure you're reading about
I'm not old enough.
you're
I'm
please
22.
please mute. I'm sure you're reading about a lot of this stuff and hearing about it on the news, but this is why some states are challenging the new rules, because it expands the sex discrimination protections for LGBTQ plus students. It changes how schools respond to and investigate reports of sexual misconduct and sexual harassment. And the claim is that they infringe on the rights of the accused students. It expands the definition of sex-based discrimination to include bias on sexual orientation and gender identity. And, it goes as far as the fear of if you refer to a student with the wrong pronoun, it could constitute conduct that is sufficiently severe or pervasive and causes that hostile environment. And then there's conflict with current state laws, especially those aimed at preventing transgender students from accessing bathrooms or sports teams that align with their gender identity. So that's where the clash is coming, and those are some of the reasons why some states are really fighting against the new rule. Pregnant and parenting students, again, a lot of sources of law, but we focus on the Title IX language because that is education. The other laws, a lot of those are employment law related. But if we look at the Title IX regs relative to pregnancy discrimination, this is from that section 106.40. And I just highlighted some of the words. A school can't exclude a student from school or an extracurricular activity because they're pregnant, or they have a child, or they terminated the pregnancy, or they're recovering from any of those conditions. They can't require a pregnant student to submit a medical release. They can do so only if the school requires that release from other students that are dealing with medical conditions. It goes back to the day. I can remember when I was in high school, if a girl got pregnant, she disappeared. We never saw her again. And this is that accommodation, if you will, for pregnant students to continue their education, to ensure fair and appropriate public education without discrimination. So, again, pregnant students must be excused as long as it's deemed medically necessary. And again, services have to be provided, just like if it was a temporary disability. We've got schools must make special programs available, must be voluntary, and so on. So, and again, this is some terminology from the Dear Colleague letter that came out in 2007. And those Dear Colleague letters come out periodically to reinforce the law, help provide clarity in the law. So you'll see those a lot. But again, this one came out in 2007 just to clarify any misconceptions and to make sure that schools understand that they must appropriately accommodate pregnant and parenting students. And so the 2024 regs add some more stuff to it. And again, they prohibit schools from treating students, employees, and applicants differently on the basis of sex regarding parental, family, or marital status. And not only do the new regs prohibit this type of discrimination, but they also require schools to take action to ensure equal access, including reasonable modifications for students, reasonable break time for lactation for employees, and lactation spaces for students and employees. So accommodations. And that's what we do in public ed. We accommodate. And so the bottom line with a pregnant student is this: they have the right to stay in school. They have the right to stay in the same classes and extracurricular activities. They have the right for reasonable accommodations as needed. They have the right to be excused absences for pregnant related conditions and needs. They have a right to lactation spaces and breaks. They have a right to learn free from harassment. They have a right to learn free from sex discrimination based on their parental status. And they have a right to be told about these rights. And they need to know the laws of the land and state and local laws. So that's the changes in that. These documents actually came out from the Department of Education. The one on the left came out in 2022. The one on the right's been out for a number of years. And Carol or Kathy, whoever, if you want, I can email some of these documents to you if you ever want to share them with the membership. These documents just came out recently, fairly recently, from the National Women's Law Center. Again, it's supporting pregnant and parenting students in middle school and high schools. And again, I can share those documents with you as well if you're interested. All right, I'm moving along, folks. I know I'm clipping pretty fast here, but I want to get through everything. And hopefully, if we have any time for conversation at the end, we can do that. But jumping into athletics, know this about athletics compliance, that the 2024 regs require schools to continue using the current guidance relative to Title IX athletics compliance. So nothing changes regarding the compliance framework to ensure that schools provide Title IX compliant athletic programs. And really, again, these documents came out last year from the Department of Ed. It's really the first time I've ever seen the Department of Ed put out documents relative to athletics compliance. So this was kind of historic. But the schools are still expected and required to do two things relative to athletics compliance. The first thing is to provide equal opportunities for boys and girls to become interscholastic athletes. The second thing is to provide equitable treatment once they become interscholastic athletes in the girls program as compared to the boys program. Two things, and that's K-12, two things. And the way schools do that or need to do that, the way they ensure that they're providing equal opportunities for boys and girls to become interscholastic athletes is something called the three-prong test. And, you know, I don't have time to go through what the three-prong test is. That's a whole different presentation. But you need to know that your school district needs to be following this three-prong test, and then there's a little two-prong test that goes with it to ensure that your school is providing equal opportunity for girls and boys to be interscholastic athletes. And then once they become interscholastic athletes, you got to make sure your school provides equitable treatment in these 11 program areas that we commonly call the laundry list. And there are factors within each of these 11 program areas that schools need to be following. So that's, you know, that's what they should be doing. And it's all about the documentation, folks, that you want to make sure that your school district is assessing, doing self-assessments as far as their athletics compliance goes. It's all about documentation. It's all about data-driven decision-making. So, you know, again, the Office for Civil Rights isn't going to pick a school and come in and do a surprise inspection. It's on the school district to make sure they're complying. And so as stakeholders, we want to make sure that our school districts are following athletics compliance. And again, there's a lot of importance as far as schools athletic compliance goes. And really it's, you know, it's the law. So follow the law. And, you know, when I talk to athletic directors, I talk to them about how important it is to assess your athletic program. If for anything else, you know, how are you doing? Really kind of see how you're doing as a school and what can you do better? What things are you doing well? And it really is the right thing for all students that you serve. And so the bottom line with athletics compliance is that nothing has changed with the 2024 regulations as far as athletics compliance. Schools should be monitoring their Title IX compliance annually. District Title IX coordinators and school district athletic directors should be working in collaboration to make sure that they're in athletics compliance. And stakeholders, all of you, should speak out when you see issues arise. And you should be expecting your school to follow the law relative to athletics compliance. All right, deep breath. Here we go. I'm going to give you as much clarity on the transgender athlete participation piece as I possibly can. But please know, and I think you know this is controversial. This is evolving. There's a lot that we're waiting for. So I'm going to give you as much information as I can, much of which is background information on kind of how we got here. So the first thing I want to start with is sources of law. And I'm going to kind of go through each of these bullets and try to explain as quickly as I can these different sources of law. The first, of course, the 14th Amendment Equal Protection Clause and Title IX of the Education Amendments of 1972 are two of the most important sources of law relative to this topic. Now, the Equal Protection Clause prohibits gender-based discrimination, and then parallel to that is Title IX, which prohibits gender discrimination in educational institutions receiving federal funds. Now, follow me on this, folks. I'm going to that yellow highlighted area. So stay with me because it's funky. The Executive Order 13988 on January 20th of 2021, Inauguration Day, President Biden signed a series of executive orders, including Executive Order 13988, entitled Preventing and Combating Discrimination on the Basis of Gender Identity or Sexual Orientation. And this executive order explicitly reinstates protections against discrimination for LGBTQ plus individuals, students, and student athletes. Now, I think some make it sound like this is the only this is only happening in the Biden administration, when in fact these protections had been developed and implemented during the 2 terms of President Clinton's administration and continuing during the 2 terms of President George W. Bush's administration and extending through the 2 terms of President Obama's tenure in office. So with the clear trend emerging that the word sex, quote unquote, in Title IX references gender identity, not gender at birth. So there's been it's not just happening in the Biden administration. This has been kind of building through the several presidential administrations. Go to that next bullet. The U.S. Department of Justice Civil Rights Division on Bostock, which is a court case, Title IX and on LGBTQ rights. In March of 2021, the Civil Rights Division of the Department of Justice issued a memorandum on whether Bostock versus Clayton County applies to Title IX. Now, just hang on to that, because the next slide, I'm going to explain to you what Bostock versus Clayton County is. So the memo concludes this memo says is it was sent to the civil rights directors at federal agencies and cites the 2020 U.S. Supreme Court decision in Bostock versus Clayton County, which found that an employer who fires a worker merely for being gay or transgender violates Title VII, the federal law that prohibits discrimination on the basis of sex in employment situations. So hang on to that. Next bullet. The U.S. Department of Education's OCR, Office for Civil Rights, Notice of Interpretations on applicability to Title IX of the U.S. Supreme Court ruling on Bostock in 2021 stated that Title IX prohibits discrimination against LGBTQ plus students and employees in public schools, colleges, universities, and other recipients of federal funding. The Notice of Interpretations was to ensure clarity in clarifying that Title IX's prohibition to discrimination on the basis of sex encompasses discrimination on the basis of sexual orientation and gender identity. And those yellow highlighted bullets, folks, this is the controversy. And the controversy and argument with these 3 declarations is that the Biden administration did not follow the new rulemaking process relative to Title IX. They just declared, hey, it was ruled in Bostock through Title VII that you can't discriminate against LGBTQ plus people, so that automatically transfers to Title IX. And the argument is, well, no, it doesn't, because you didn't go through the rulemaking process. And that is really a big conflict in this whole kind of evolution of transgender participation. And what are we doing? The last 2 bullets, just real quick, the 2016 Dear Colleague letter and the 2016 guidance issued during the Obama administration, which was actually rescinded by the Trump administration in 2017 and then reinstated by the Biden administration in 2021, states that it is gender identity that controls the determination of sex, not anatomical gender at birth. And so it requires that students are allowed to participate in school activities and use school facilities consistent with gender identity. So, man, you got this back and forth going on with the different administrations. All right, hang on to your hat. I need to explain Bostock to you if you're not familiar with it. So Bostock versus Clayton County, Georgia, was a United States Supreme Court decision in 2020. This is significant because it's kind of really playing heavy in all of this. And the Bostock decision was actually 3 cases. There was Gerald Bostock, who was a child welfare advocate who was terminated by the Clayton County. He worked for the county, and he was terminated by the county for unbecoming conduct after he began participating in a gay softball rec league. And that lower court decision came out of the 11th Circuit, and the 11th Circuit found that law does not prohibit firing on the basis of being gay. Now, if you know anything about the circuit courts, the 11th Circuit includes Florida, Georgia, Alabama. All right, so hang on to that. So the lower court ruled in favor of the firing, and this is why Bostock appealed to the Supreme Court and got certiorari, got the Supreme Court to hear his case. Now, along with that was Donald Zarda, who was a skydiving instructor, was terminated from his job days after mentioning he was gay. And the lower court, the Second Circuit, determined or ruled that sexual orientation discrimination does violate. Remember, we're talking about Title VII. We're not talking about Title IX. We're talking about Title VII in employment. So the Second Circuit ruled that sexual orientation discrimination does violate Title VII. And if you know anything about the circuit, again, the Second Circuit is New York, Vermont, Connecticut. And then we had Amy Stevens, who worked for a funeral home, presented as a male when hired, but was terminated after she told her employer she planned to live and work as a woman. And so the Sixth Circuit ruled that Title VII bars employers from firing employees because of transgender status. And the Sixth Circuit is Ohio, Kentucky, and Tennessee. So all of these cases were kind of lumped together and went to the U.S. Supreme Court. And the Supreme Court ruled, and I'm just going to go through some of the language from the court documents, if you will, not to bore you or give you a lot of verbiage to look at, but this is some of the language that came out of the ruling, if you will, that an employer violates Title VII when it intentionally fires an individual employee based on, in part, on sex. And yada, 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 it goes on. And the key is at the end, if changing the employee's sex would have yielded a different choice by the employer, a statutory violation has occurred. And again, they go on to say that Title VII's message is simple but momentous, and an individual's employee's sex is not relevant to the selection, evaluation, or compensation of employees. And then they go on to say, again, a lot of verbiage. Sorry about that. A lot of words. But I think that the ruling and the language of the ruling is important in this case. And if you kind of read through this and get to the end of it, where Title VII, Congress adopted broad language, making it illegal for an employer to rely on employee's sex when deciding to fire that employee. So we the court, do not hesitate to recognize today a necessary consequence of that legislative choice. And an employer who fires an individual merely for being gay or transgender defies the law. So that was a big ruling, huge ruling. And now this Bostock decision is really coming into play. And so the controversy with the Bostock decision is what they're saying is, what people against this are saying is that Bostock is a decision regarding Title VII, not Title IX. Title VII's employment. And the Biden administration claims that the Supreme Court's decision in Bostock would apply to Title IX to include the concept of gender identity. But, Title VII and Title IX are not the same, is the claim. And unlike Title VII, Title IX explicitly allows schools to draw sex-based distinctions. The original Title IX regulations promulgated in 1975 recognized that the statute permits, and some instances requires, many sex-specific spaces and programs, and Congress ratified that understanding. So biology matters in sports and intimate places. And treating women fairly requires respect for their physical differences from men and their need for privacy. And the 2024 regulations appear to ignore this language and directly addresses locker rooms, showers, and bathrooms. So, this is a big deal. So the Bostock decision really kind of anticipated this difference between 7 and 9. And the decision stated that it did not address other laws. You can see that in quotes, such as Title IX relative to bathrooms, locker rooms, and anything else of that kind. In fact, I believe it was Justice Gorsuch who said, hey, the Bostock decision is not a determination on bathrooms or locker rooms. That will come later, he said, something to that effect. So kind of hang on that and chew on that a little bit. It's kind of interesting. There's other case law that is significant in all of this as this continues to evolve in our nation and in our schools. And we try to figure this out. And just real quick to go through some of this case law, I think the first really attention to transgender students came in 2014 with the GG case. Gavin Grimm, we can now say who it is because Gavin Grimm has graduated. But this was from the U.S. Fourth Circuit of Appeals that ruled in favor of Gavin Grimm. And Gavin Grimm in 2014 was a sophomore at his high school, and he was banned from using, transgender male, banned from using the boys' restroom, and filed a lawsuit resulting in a June 2016 Fourth Circuit decision that the term sex in the Title IX statute refers to gender identity, not biological gender at birth. So this one really kind of put everything on the map and drew attention. And then we started to see the lower court rulings relative to what is sex. And in the Gavin Grimm case, that circuit court ruled in favor of Grimm that it's gender identity. Boyertown case in 2016, this was this was headed to the U.S. Supreme Court and didn't quite make it because we had a presidential election and then things happened and the court denied certiorari, so it didn't get there. But this was a case where in a 2018 ruling, a 3-judge panel in the U.S. Court of Appeals for the Third Circuit rejected claims made by 6 cisgender students. So cisgender is individual who identifies by their gender at birth. At Boyertown Area School District at this high school argued that their rights were violated because of having to encounter transgender teens using the restrooms or locker rooms at the school consistent with their gender identity. So kind of a different kind of lawsuit, if you will. But the a Court of Appeals really denied the request of the appellants for an en banc hearing, which is all 12 judges. And the thing about Boyertown Area School District is they implemented a new policy allowing students to use the restrooms or locker rooms consistent with their gender identity. And they included a procedure through which the transgender student applies and receives approval from a team of trained school counselors and administrators before receiving permission to use the gender-aligned facilities of their choice. I really think Boyertown, my opinion, was really ahead of their time. And they really had their act, or do have their act together. They also constructed numerous single-user bathrooms, and there's 8 at the high school. They provided alternative dressing rooms attached to locker rooms, private shower stalls. So they really, I mean, they really went the extra mile to accommodate and provide facilities, and then having that process for transgender students to go through with a team, I think is groundbreaking. The Adams case was August of 2020, 11th Circuit. So this is in Florida. And Drew Adams, a transgender male, the school prevented him from using the school facility, the restrooms, the locker rooms corresponding to his gender identity. So this kind of weaved through the courts, if you will. I'm cutting this short for lack of time, but ultimately there was a December 2022 ruling on this. Actually, what happened, the lower court ruled in favor of Adams, allowing him to use the facilities in alignment with his gender identity, but it went back on appeal. And in December of 2022, in a 7-4 en banc decision in the U.S. Court of Appeals for the 11th Circuit, they reversed the decision and said, nope, you can't use the facilities of your gender identity. It has to be the facilities of your anatomical gender at birth, and it does not violate the 14th Amendment, equal protection, or Title IX. So kind of a different ruling. The 2019 Seoul versus Connecticut Interscholastic Athletic Conference, that was when I think we saw the first really notable high school case or involving transgender athletic participation. So Selena Soule and two of her teammates, cisgender student athletes, filed a complaint with the OCR against the Connecticut Interscholastic Athletic Conference, challenging the policy that permits transgender student athletes to compete based on their gender identity. And they also filed a parallel federal lawsuit. And again, long story short, this went back and forth in the courts. There was supposed to be an appeal on this in the Second Circuit in New York, but I haven't heard anything lately on it. But all student athletes have since graduated. Selena Soule and her teammates have gone on to college and are participating on the track team. And the transgender females that they filed suit against have gone on to college, but are not participating in athletics. So just an interesting case. The Hecox case, this was Lindsay Hecox, and among the dozen or so anti-trans laws that were introduced in 2020, Idaho, their House Bill 500, which bans women and girls who are transgender from participating in sports, was actually the first one that was introduced. And Governor Brad Little signed that bill into law in March of 2020, and Idaho became that first state. And Lindsay Hecox is a transgender female and a student at Boise State University, and she ran cross country, and she filed a federal lawsuit to challenge that ban, and it worked its way through the courts, kind of went back and forth. And as far as I know, she's won that case and had continued to participate in athletics at Boise State. And then finally, I wanted to throw the Mac Beggs case in there. Mac Beggs is a transgender male in Texas. Well, since graduated, Mac Beggs is now out of high school. But in 2017, transgender male was undergoing the transitioning process while in high school to become a male, but was forced to wrestle. He was a wrestler against females in the state championship because the Texas Athletic Association, the policy required that student athletes compete based on their sex listed on their birth certificates. So Mac Beggs and his parents wanted to wrestle in the boys division, but Texas would not let him. And he wound up both his junior and senior year just kicking butt and winning the state championship, and at the same time going through tremendous harassment and just abusive comments. So just some real quick case law that I wanted to run through. So the new regs, so the first time since the Title IX regs were codified in 1975, there's going to be athletic regulations that are going to be issued after the election in November, and that will address transgender student participation in interscholastic athletes, and the Biden administration is going and has gone through the new rulemaking process on this. So here's what we think it's going to say. We think basically, and as you're reading the slide, basically the proposed rule would permit schools to adopt or apply sex-related criteria that would limit or deny students' eligibility to participate on a male or female team consistent with their gender identity, as long as the criteria is tailored to the particular sport, level of competition, and grade or education level of the students. And any sex-related criteria restricting the participation of transgender students must fulfill two requirements. One, be substantially related to the achievement of an important educational objective, and two, minimize harm to students who are limited or denied their participation on a male or female team because of their gender identity. So what does that mean? Who the heck knows? They're trying to give schools criteria to really determine whether or not a transgender student should or can participate in a particular team. And let's face it, folks, we're talking about transgender females, because you're hearing all the stuff that's going on about all of the issues relative to transgender female participation. One thing we know the rule will say is there's no blanket ban, no one size fits all ban on transgender students. So my fear, not my fear, but my concern is that ultimately the decision will be put on the schools, the individual schools, to decide to adopt policies, to adopt processes on either limiting transgender participation or incorporating transgender participation. Under the proposed rule, each school would have to take into consideration things like differences in education level, differences in competition level, differences in types of sports offered at the school, different sports governing bodies criteria for eligibility. So all the states have individual athletic associations and their rules, and how to minimize harm to students who participate would be prevented or limited. Well, how do you determine that? You have to let somebody participate in order to harm to happen. So it's going to be challenging. And as this evolves and we try to figure it out, my concern is that, schools are going to be left with, well, it's up to each individual school. Who knows? We'll see. But really, folks, the bottom line is, what is the definition of sex? And that's the quagmire. That's the challenge. Is it anatomical gender at birth? And we have 24 states that have bans on transgender participation, mostly bans on transgender female participation based on biology, or is it gender identity? And that's the crux of the 2024 regs that'll come out in November. And, that is all based on subjective internal perceptions, in my opinion. So here's the challenge for transgender student athletes, and schools. It's like, it's the law, it's science, it's inclusion, it's fairness. Where does it all end up? Where does it all come together? The issue clearly becomes more concerning or greater at the high school and the elite sports level. We know that. Elementary, they all play together. It's pretty equal. Middle school, not, it's basically not an issue. But as kids get older, biology changes. So that's the challenge. Like, how do we make it all fit? Just a couple of statistics, folks. And there's not a lot of information out there on transgender folks or transgender student athletes. So I took this from the Williams Institute. This is from 2022, a pretty interesting study. If you're interested, just Google Williams Institute. Estimated 332 million people in the US, about 1.3 million adults, 300,000 youth ages 3 to 17 identify as transgender. So 0.5%, 1.4% of the population respectively. not all transgender people identify as women. An even smaller number consists of transgender women hoping to compete in girls and women's sports. Privacy laws make it difficult to identify the exact number of transgender athletes competing in public schools. But the estimates are there. So there's a lack of information, which, makes it problematic as well. From my perspective, again, opinion, my K-12 perspective, this is what I worry about. I worry about mental health, and I worry about inclusion and helping kids. We know the benefits that sports offer kids who participate. The mental health benefits, the fitness benefits, the belonging, being on a team, competing. We all get that. So I don't know what the answer is. I don't have the answer, but some things to think about including kids, and how do we find a space for kids to be included? All kids, LGBTQ kids and people have been around for a long time. This is not a new thing. It's becoming a highlight in our country because of various reasons. But I hope we can figure this out. Just some resources. If you go to transathlete.com, you can track all the policies, the K-12 policies across the country in every state. Just kind of FYI, if you want to make note of that. I study this stuff, folks. I find it absolutely fascinating. And so these 3 books are very interesting if you're so inclined. Fair Play, all the way on your left, just came out last year. I read that in like 2 days, and I don't read. And it is absolutely fascinating. And Katie Barnes does a really nice job about talking about the history of women's sports, and goes into the science and medicine of trans athletes. Sporting Genders, a little bit of an older book, but again, very fascinating, talks about the biology and science of transgender people. And then Caster Semenya, her book just came out last year. And if you don't know Caster Semenya, she is a world-class track athlete, and she is intersex, and she is always identified as female, and just won a big lawsuit with the international track community. They were trying to ban her from elite competition, but she just won that lawsuit. But fascinating story. So here's the bottom line, folks, and then I'll get out of your hair. From a K-12 perspective, and this is where my lens is, because I'm K-12 in and out. I'm on a school board. I worked in K-12 education my entire life. Here's where I'm at. Courts have determined that we got 2 jobs in K-12, folks: to educate all students, with the emphasis on all. We educate everyone in public schools. And the second thing, and it's a close second, to provide a safe and orderly environment for students to learn, all students, and really protect the health, safety, and welfare of all students. And that's our job, to educate kids and to keep them safe. So that being said, I just want to share this little thing with you. This is an excerpt from the 2017 Dear Colleague letter that came out of the Trump administration, that rolled back the 2016 guidance from Obama. Obama's letter said, hey, it's gender identity, sex is gender identity. Trump rolls it back in 2017 saying, nope, it's anatomical gender at birth. But in that Dear Colleague letter, on the last page, they reference the importance to make sure that all kids are protected from discrimination, bullying, harassment, including LGBTQ kids. So we're keeping kids safe. So where do we go from here? Hey, we're waiting. We're waiting for them to come out, the regs to come out. We're going to wait and see what happens in the coming months. I'm sure you're all tuned into the media and what's happening on the news. Keep reading, keep learning, folks. I've got stuff I can send you. Consider getting 1 or 2 of those books and read about this stuff. It's fascinating information. Keep educating. We want to learn, we want to educate, and we want to hope. And hopefully we can see where this all lands, and that we're taking care of our kids and providing safe spaces for all our kids, and and really coming to an understanding. And that's just my lens. Here's some resources, folks, if you want to take a screenshot. But I'm here to help. Again, thank you so much I went a little bit over. There's my contact information. Again, I find this stuff fascinating, and I'm more than happy to help. I don't know if there's any questions, if you want to hang around for questions or comments, but that's all I got.
So I finally got my sound and visual back.
All right.
Peg, thank you so much. You just gave us so much to think about here. This was unbelievable, an unbelievable presentation, and so complicated, so
it is.
complicated.
It is. It really is. Yeah.
You really helped in terms of the whole education process and knowing all the legislation that's out there. I remember last time you talked about the letter of the law, but then there was another category, like,
Spirit of the law.
Yeah, the spirit.
Yeah,
Yes, I couldn't remember that other word.
Yeah.
And that's kind of where we are with this.
Yeah, what really bothers me, I think, the most is with the transgender female situation. Listen, I get it. I get the concern about competitive fairness and opportunities for girls and all of that. What I get bothered with is when the claim is made that transgender females are going to destroy girls' sports. And because I come from the lens of, if the governmental entities, if all these state governments really cared about girls' sports, then they would have been pressuring schools to enforce the law from the get-go, meaning, make sure your school is in compliance, make sure they're providing equal opportunities for girls and boys to be athletes. I struggle with that one. So yeah, I just hope we can find a place for all kids. Because again, it goes back to, that's what we do in public education. We accommodate. I mean, look at what we do. I think public education is amazing. I mean, we try to do the impossible.
Reports by people who work in athletics and public ed, and their take was, just let the kids play. That's really all they want to do. They just want to play sports. They just want to be on a team and participate.
Yeah.
So,
but I think
would you mind putting us in a gallery, taking your slide?
I'll stop sharing.
So I can get a screenshot of everybody.
I'll stop sharing, and then we can chat if you want to hang around.
So if people will put their faces on, I'll take a picture of everybody.
Oh, hey.
Good
to see everyone.
Just give me a second here to get a picture of everybody.
Yeah, I certainly didn't want to get into the political stuff, because we all know what's going on. I mean, I just hope we can find a resolution. I hope we can figure it out for kids. That's all where I'm coming from.
Right. I agree.
So, and as you probably all noticed, I didn't bring up Leah Thomas. I didn't bring up,
right.
Because, I think, poor Leah Thomas is getting battered all over the place, and the thing about Leah Thomas is, I don't blame her. She followed the NCAA requirements. She went through the transition. She did what she was told, and she didn't win every race. And at the end of the day, she was ranked, I think, like 48th nationally. So, again, it's how it rolls.
And so what I was reading was that there was so much attention paid to her participation in that sport, way more attention than was ever paid to that sport before.
Yeah.
So,
yeah.
And that's kind of what you were saying.
Yeah. Yeah. So, but it's,
so
yeah,
this has been recorded, and all the slides at the resources listed on, that'll be available for everyone as well.
Good. And Carol, just let me know if you want me to email you some of those documents to share
Absolutely,
with everyone.
absolutely.
Do that for, for just for a resource, but
Those books you were recommending, would one of them be appropriate for our book club, do you think?
yeah, I mean, I think Katie Barnes's book, that first one, that Fair Play book, I think would be a great read. It's very educational. I mean, it's kind of eye-opening, and it gives you, she does a really good job at giving you that background story of women's athletics and the history of women's athletics, and breaking down those gender stereotypes and all that kind of stuff. So yeah.
Does anyone else have a question for Peg?
Or comment, like, I'd love to know how you all feel about all this. It's
Well,
I'm sure Terry has an opinion.
Carol, you're calling me out.
Well, I know you're always very reluctant to share your thoughts, but
I would love to hear this again, not necessarily the same content, Peg, but it's just a very hard subject for certain people. And I was on a call not that long ago where what you had said mentioned just briefly. The comment that was made was that it's ruining women's sports. And the only thing I could say to that was, how many people are we talking about? I mean, that was one of the things that you had in your slides. It's, it's such a small number of transgender students that, to me, but this is my opinion, it's insignificant. It just doesn't matter. Now, I did not play sports in college. I played sports in high school, but I come from a family of athletes, and their opinion is, well, their opinion is, it doesn't matter. Just let the person play in the sport that they identify with, the gender that they identify with. But that's not, I mean, obviously that's not a commonly held opinion.
Yeah, well, I didn't get into this, and I don't know if I should get into it, but I'll mention it among friends here. That slide that I put up, that I actually created it. It's the center circle with the student athlete, and then those four around, the science, the law, the inclusion and fairness. And what I didn't include was, and it is what it is, folks, is the political climate that we're in. And I mean, let's face it, there are many who believe that this is morally wrong to identify as transgender or any LGBTQ is morally, we get into the moral and ethics of it. And I think that's where some people go with it. And we're trying to figure out who we are. It's like, yeah, I don't know. We'll see.
well, when you're in an organization that is advocating for women's rights, that's kind of clear what to me anyway.
Well, and it's like I said, in the presentation, LGBTQ people have been around forever, and now, well, I see it on school board. I see the attacks come from some of our community members and a couple of our school board members, the fight against DEI and, all of that. It's just where we are right now in our country.
Yeah.
And,
Well, when you see librarians being attacked and books being taken out of libraries, then all bets are off then.
Yeah. So.
Well, thank you again. Thank you so much for your time. All the
Thank
effort
you.
you put into that. It was just awesome. We really appreciate it.
I really appreciate the opportunity, and anytime I get to talk about Title IX, I could talk for hours. So I appreciate it. I appreciate appreciate your willingness to listen and understand the law. It's so important to me that people understand the law, and
Yeah, and it's complicated.
it is. It is. Yeah.
Mhm.
All
So,
right,
so
Contact
Peg,
me,
you would be willing to do Title IX 101, huh?
Yeah, I mean,
To come back again.
yeah, we can, we can bat it around some more. It's, let's see where we are in a couple weeks or months, and could be interesting. But yeah, I'd love to maybe just have a little chat session with everyone. Be fun.
okay, that sounds great.
Yeah.
Thank you.
Thanks, everyone.
All right,
Excellent
bye.
presentation.
Thank you all for coming.
Excellent.
Thank you.